This program is not intended to replace professional legal advice or representation. If you have a legal concern, you are strongly encouraged to seek the advice of an attorney.
Hello everyone, I'm Yanique Otto, attorney at law in South Florida with the Otto Law Group. Thanks for joining us for this episode of Now You Know the Law. So you've had a child with someone. Maybe you were married, maybe not. But for whatever reason, the relationship has disintegrated and you're going your separate ways. Both parties, however, want full custody of the children. Here's what you need to know. In Florida, courts prefer a shared custody arrangement, allowing both parents quality, liberal time with their child. In fact, we don't so much use the word custody anymore. Instead, we use the term time sharing. Time sharing is a type of visitation in which one parent is usually awarded the physical custody of the child, while the other parent receives generous visitation rights or shares the time spent with a child. In making determinations regarding time sharing, Florida courts are governed by the best interest of the child standard. The court has to weigh several factors in determining what is in the best interest of the child, whether he should spend the majority of his time with the mom or dad, or whether time should be divided equally. The statute that governs this lists over 20 factors that must be considered by the court in reaching this decision. Here are just a few. The mental, physical, and emotional health of the parents. Any history of child abuse, domestic violence, child neglect, or abandonment. The parent's ability to respond to the needs of the child and not his or her own needs. And also the stability of the home that each parent can provide for the child. Now, back in the day, it used to be presumed that the mother was in the best position to care for the child, and the father would have some rights, but not the best rights. He may be given, for example, weekend visitations or sometimes just every other weekend. You should know that this is no longer the presumption under Florida family laws. Both parents are deemed equally fit and qualified to provide care for their children. It doesn't matter that one parent does not want the other parent to see the child for moral reasons or any other reasons, things like smoking weed, too much partying, multiple sexual partners, and so on. That parent would have to show under the law that the other parent is unfit to raise a child based on the factors we discussed earlier and the others listed in the statute. So here's the bottom line. A complete parenting plan includes lots of information about where the child stays, with whom, what days, and making decisions about the child's health, extracurricular activities, education, and so on. It's a very nuanced process, but a competent attorney can assist you in navigating this kind of matter. If you're facing a divorce, a child support, or child custody issue, give us a call and we can help you. Thanks for joining us. I'm Yanique Otto. We'll see you next time, and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.